At-will employment is a legal doctrine that affects millions of American workers, yet many don't fully understand what it means for their job security. In most states, at-will employment allows either an employer or employee to end the working relationship at any time, for almost any reason, without notice. At-will employment is the default rule in 49 of the 50 states. Montana stands alone as the only state that does not fully adhere to this doctrine, requiring employers to show just cause for termination after a probationary period. In all other states, employers can adopt at-will policies that give them broad discretion to terminate employees. Many job applicants are surprised to discover that their employment application or company policies establish them as at-will employees. This means they can be fired at any time without cause. Additionally, employers can change benefits, hours, and wages without providing notice or justification. How do you know if you're an at-will employee? Unless your employment contract specifically states otherwise, you are most likely employed at will. The burden falls on you to prove you're not an at-will employee, typically through written documents or oral statements from your employer that might constitute an implied contract. Employment documents play a crucial role in determining your status. Many employers explicitly state in applications, handbooks, or policy manuals that workers are at-will employees subject to termination without cause or notice. If you've signed such a document, you will likely have limited recourse if terminated. However, if your employee handbook outlines specific termination procedures or states employees won't be fired without cause, you might have some protection. Several misconceptions surround at-will employment. Many employees incorrectly believe they have no legal protection against termination. While at-will employment does provide employers with flexibility, it does not override federal or state laws prohibiting discrimination, retaliation, or termination for protected activities. Another common misunderstanding is that signing an at-will agreement waives all rights to challenge a termination. In reality, these agreements cannot negate your rights under anti-discrimination laws, wage laws, or whistleblower protections. Despite the broad powers at-will employment gives to employers, there are important exceptions. The first major exception involves implied contracts. This occurs when employers include language in policies or handbooks indicating employees won't be fired without cause. Courts in 41 states and the District of Columbia recognize this exception. The second exception is the public policy exception, recognized in 43 states and Washington, D.C. This protects employees from termination for actions that serve the public interest, such as refusing to perform illegal acts, reporting violations of law, or exercising statutory rights. The third exception is the implied covenant of good faith and fair dealing. This broader exception, recognized in only 11 states including California and Alaska, can allow wrongful termination suits if employers act in bad faith, such as firing an employee to avoid paying retirement benefits or commissions. Beyond these common law exceptions, statutory protections exist at both federal and state levels. Federal laws prohibit termination based on race, gender, religion, disability, age, and other protected characteristics. They also protect employees from retaliation for whistleblowing, taking medical leave, or filing workplace claims. Some states provide additional protections for off-duty conduct, lifestyle choices, and political activities. For example, certain states have enacted smokers' rights laws that prevent employers from firing employees for using tobacco products outside of work hours. What about at-will agreements? While employees are not legally required to sign them, employers may refuse to hire or may terminate those who decline. However, signing such an agreement does not eliminate rights protected by law or override terms in existing employment contracts. For employers, best practices include clearly defining at-will status in all employment documents, avoiding verbal promises about job security, training managers on the legal implications of their statements, and documenting all disciplinary actions. As an employee, you should be cautious about signing at-will agreements if your employer has made specific promises about job security or employment terms that contradict the at-will nature of the agreement. Such discrepancies can create legal confusion and potentially undermine your protections. Understanding at-will employment is essential for both employers and employees. While it provides flexibility in the employment relationship, it does not give employers unlimited power to terminate workers. Clear communication and documentation from both parties can minimize confusion and disputes, creating a more stable and predictable working environment despite the inherent uncertainty of at-will employment.